The handout has 9 distinctions Eric's book doesn't pay enough attention to. Don't panic. I will only cover 2 of them. So first, my issue with the title and the thesis. Eric sees originalism as an act of faith, of misplaced faith in the Supreme Court and of the court's ability to promote the rule of law via historically grounded interpretation. No. That's not even the kind of thing that originalism is. Originalism does not look out at the Supreme Court and say, that's the kind of thing that can promote the rule of law. Originalism looks out at the Constitution and said, that is the kind of thing whose meaning stays the same, and looks at the court and says, that's the kind of thing that should treat the Constitution as if its meaning stays the same. I probably don't need to remind any of you, originalism did not begin its life as a word as a brand for the Republican Party. It began life as a term that Paul Brest invented in order to characterize his opponents. By originalism, Paul Brest says, I mean the familiar approach to constitutional adjudication that accords binding authority to the text of the Constitution or the intentions of its adopters. So a lot of people agree with that. That's why we call them originalists, following Brest's usage. Okay, so the last 50 years or so, philosophers of language have talked a lot about directions of fit. So users of language with a mind-to-world direction of fit, from mind to the world, they're trying to match something out there in the world, maybe the contingent material world, maybe something in the Platonic realm of numbers, Phrygian senses, and the like. So on the one side of the distinction, we've got beliefs, theories, knowledge, guesses, and the like. With a world-to-mind direction of fit, on the other hand, the mind is trying to get the world to match it. So on the other side of the distinction, we've got desires, plans, projects, wishes, hopes, commitments, and their kin. This distinction allows us to ask, are constitutional theories collections of beliefs, or do they instead consist of desires, or both? Originalism as faith views originalism as purely an unsuccessful political project to get the court to behave lawfully. But I don't think at its root, originalism is that kind of thing at all. In 1957, Elizabeth Anscombe asked philosophers to imagine a shopper sent to the grocery store with a list of items to buy, followed by a spy writing down what the shopper gets. So as the shopper fills the cart, the spy eventually accumulates a list of items identical to the grocery list. Both lists match the shopping cart, but the 2 lists have very different criteria for success. So suppose the shopper gets vanilla yogurt instead of plain yogurt, which was on the list. And imagine the spy makes the same mistake, writing down plain yogurt instead of vanilla yogurt. The 2 lists are now the same, but the spy's list is now flawed in a way the shopper's is not. The spy who sees that the yogurt in the shopper's cart is actually vanilla can cross out plain and write vanilla. But the shopper, looking down at the cart and noticing the wrong kind of yogurt, can't simply edit the shopping list to match the cart. You're supposed to laugh at that too. Okay, why not? Because a shopping list has a world-to-mind direction of fit. The point is to make the world, the shopping cart, and eventually a refrigerator match the desires of whoever composed the list. But the spy's report has a mind-to-world direction of fit. The point is to actually accurately track what the shopper's buying. The Article 6 constitutional oath converts beliefs about the Constitution's requirements into commitments to put those requirements into effect. As interpreters' minds fill with beliefs matching the Constitution, their constitutional oaths impel them to take those beliefs and, within the scope of their offices, make the world fit them. The Constitution, itself a chunk of the world, thus has an effect on other parts of the world through the medium of oath-taking interpreters' minds. Stage 1 has a mind-to-world direction of fit, and the oath-required Stage 2 has a world-to-mind direction of fit. Okay, so what do I make of all the smack Eric talks about the Supreme Court? It's telling that Eric's focus is not on the most serious scholarship on the Constitution, like my Equal Protection Clause stuff, Mike Rappaport's work on colorblindness, or Will Bode and Gary Lawson's work on the Necessary Proper Clause, or piles of other stuff I'll list in a footnote in a book review someday. Eric focuses only on the court, but originalism isn't about the court, not in a mind-to-world direction of fit way. We're trying to match the Constitution, not the court. Originalists generally have views about the court, but not views that can be made false because of what the court is doing. For the Constitution, we've got beliefs, and for the court, we've got unfulfilled desires. Basically the desire, stop making stuff up, sometimes vulgarly expressed. So why should they stop making stuff up? Because they're oath-bound to the actual Constitution, not just good policy, and also not the Constitution as they understand it. The actual Constitution uses words like now and he that make no sense interpreted as if spoken today or tomorrow. Principles that the oath makes obligatory aren't falsified by the court's failure to apply them consistently, even Scalia's failure or Gorsuch's. So when I look at a piece of constitutional theory, I always do a Control F for oath. If I find nothing, which alas I did for Eric's book, I know right away I'm not going to be too impressed at the normative arguments. However evil the nation was in 1787 or 1791 or 1868, and I don't minimize that in the slightest, the justices made promises to us in 1988, 91, 93, and 94, and 2005, 6, 9, 10, and 17. Those promises are binding. So let's talk about Roe and Obergefell. If you look at Joseph Telepenna's work, statutes in 27 of the 37 states in 1868 punished abortion even before quickening, not even counting common law prohibitions that might have done so too. So the 14th Amendment adopters didn't think they were legalizing abortion. Same-sex marriage was unknown. They obviously didn't think they were requiring it. Is that the end of the story for originalism, Roe, and Obergefell? No. The sense-reference distinction allows unchanging sense to be applied to changing or framer misunderstood facts. So we see that in the interim House representation rules that the framers thought Maryland was more populous than North Carolina, but this mistake isn't binding today. The oath commits us instead to the sense historically expressed by respective numbers in Article 1, Section 2, Clause 3. So this is what Arthur Machen said in 1900, and the court said in Euclid in 1926. Building cars changes the referent of the term car, the collection of cars out there in the world, but not its meaning. So this is what Jacobus Tenbrook emphatically denied in 1939, inferring changing meaning from changing application. Truth be told, about a third of philosophers today would agree with him, but they're wrong. Now, the sense historically expressed by the Privileges or Immunities Clause was, and I'll just presuppose my own views here, equality and civil rights among similarly situated citizens of the United States. So, if, contrary to fact, Michael Tooley is right that fetuses don't have significant moral worth, then pregnant women are similarly situated to non-pregnant citizens of the United States, and the Privileges or Immunities Clause guarantees legal abortion. Or if, again contrary to fact, Judith Thompson is right, then whatever fetal worth there is can't justify restrictions on maternal bodily integrity, the same conclusion follows. Similar situatedness depends on the moral facts. Similarly for Obergefell, if same-sex couples are similarly situated to opposite-sex couples, then the Privileges or Immunity Clause requires that those couples get the same civil rights. We have to assess the interpretively relevant issue of similar situatedness in terms of the actual moral facts. The core problem with Roe and Obergefell is epistemic, not interpretive. Roe resolves the abortion controversy while remaining agnostic on the issue the court itself says is key, the status of the fetus. Well, Obergefell cites the social science data super sloppily and doesn't engage counter-arguments or reasons to keep an open mind on the policy issue. But, Eric says, that's just what living constitutionalists who want their notions of policy to trump original meaning would say. True, but that doesn't mean that analyzing the cases that way entails policy Trumpism. Eric's reasoning here seems very close to affirming the consequent, which, as Jack says, looks an awful lot like common law reasoning, but it's not logically proper. If policy trumps original meaning, reference will change, but not the converse. Changing reference doesn't entail policy trumping original meaning. So other cases force us squarely to resolve the policy trumping question, even if Roe and Obergefell do not. So think of cases about non-civil rights, political rights, like Reynolds or Bush v. Gore, or about non-citizens, like Graham v. Richardson or Yick Wo. The policy trumper might say, oh, civil rights, political rights, citizens, non-citizens, same moral difference. We know better than the framers. On my view, even though Roe and Obergefell aren't ruled out by originalism as such, this move doesn't work elsewhere because the text in its original context talks about the rights of citizens, that is, civil rights. That's also why they should use the Privileges or Immunities Clause. Because protection of the laws in Blackstone and Marbury and 100 other places means something and not just rights in general, and likewise for process of law. Sorry, I was planning to go speaking only about 160 words a minute. I think I dialed it up to about 165, so now I've got extra time. So hope the written material helps that be more comprehensible.
I do want to respond.
Eric, do you want to respond?
Yeah, I do, because I want to be clear about my project. So I think Chris and I have very different projects in mind. I think in a lot of ways, Larry, Solomon, and I have I know we have very different projects in mind. I'm trying to describe what the Supreme Court has done and what it ought to do. That's my project. And it does not make a whit of difference to any human being or insect crawling on the ground whether the meaning of equality changed from 1868 to 1954 or whether the application of equality to similar facts changed. No one. I'm on the radio like twice a week. I talk to a lot of smart non-lawyers and other things. No one cares about that, and they shouldn't care about that. So when Machen, I found this article by Machen in 1900. It is the first article ever written to use the phrase living constitution. Constitutional Commentary let me publish an article about it in 1997, which had the unfortunate title of 100 Years Lost, the End of the Originalism Debate. I guess I was wrong about that. I think Machen said most of what we need to know. Machen said that he said meanings don't change. He agreed with you. Meanings don't change, but different results can be reached by judges on the same facts in different time, places, at periods, and even in different geographic areas at the same time by a careful distinction between law and fact. But what he's really saying there is vague principles can be applied by judges over time in different ways, and that's what Mike Dorff says, and Tribe and Bobbitt and all kinds of other people. And if that's what originalism is, then I still at a loss to understand how that is different from Mike, who's not an originalist, and Bobbitt, who's not an originalist. And in my fantasy world, I explained what it was. I know that world's never going to happen, or probably not going to happen. So on my real world analysis of real cases, I do what you guys do. I mean, original meaning matters, some, but then you got to translate it. And sometimes it makes no sense, and sometimes they disagreed among themselves. At the end of the day, it's one small factor for the Supreme Court to consider, but at the end of the day, their decisions will be driven by their preferences writ large. And unless you adopt a unless you adopt a burden of proof, a strong burden of proof, that's never going to change. And if you're not going to adopt that burden of proof, then Bobbitt and Jack and Randy and Mike and Will and Steve are all correct, but that leaves me asking the question again, then what does originalism mean?